Thank you. Good evening. So I'm going to be talking primarily about three recent cases that have, with varying degrees of clarity, addressed some of the issues in relation to age discrimination. Primarily, I'm going to be talking about Woodcock, obviously about the extent to which costs can justify direct age discrimination. I'll also deal with Selden and Homer, time permitting. In the last two of those cases, the court give relatively clear guidance as to when less favourable treatment on the grounds of age will be justified. In Woodcock, however, the principles that emerge are not on the face of the judgment clear. And to understand how the courts will approach the topic of justification in age cases, it's important to have both the knowledge of the circumstances and a weather eye to the currents of judicial thought that lay under the decision that came about. Time permitting, I'll deal with three recent decisions, two ECJU and one ET decision. We'll see how we get on in time. But I'll deal firstly with the most problematic of those cases, and that's Woodcock. And some of you may be familiar with the facts already. In very broad terms, the factual circumstances were that Mr. Woodcock, the former chief executive of a trust, was dismissed early during the course of a redundancy process by reason of his age, according to the findings of the tribunal. The reason for doing so, as again found by the tribunal, was that it prevented the trust becoming liable to pay him an enhanced redundancy payment and pension. And that age-based reason was a clandestine one. It is one which the trust had denied, had never communicated to Mr. Woodcock, and one that didn't emerge until the employment tribunal. And again, I'll deal with the law in a bit more detail shortly, but the extant position in relation to the law, the ostensible position before, during and after Woodcock, appears to be relatively straightforward. That is obviously that age in principle can be justified where the reason is a proportionate means of achieving a legitimate aim. For states, cost cannot be a justification. For employers, cost alone cannot be a justification, but it can be a factor when coupled with other things. Now, notwithstanding that factual background and that legal background, the ET, the EAT and the Court of Appeal found that Mr. Woodcock's early dismissal by reason of preventing him from getting his enhanced pension was due to age, but was justified. Now, needless to say, in those circumstances, or perhaps not needless to say, Woodcock has attracted a fair share of sceptical comment as to the decision and the reasons for it. The prize for economy of expression in relation to commentary goes to Sean Jones QC on Twitter, of all places, who commented in this way. The comment was, Woodcock, here's the result we want. Here's the law, here's a hammer, bash, bash, bash. And I have to say, had the case gone to the Supreme Court, I would have had to resist the temptation to put that at the front of the permission application. In any event, it's tempting to cite Woodcock, not just because I lost, but as one of those examples of hard cases making bad law, if that didn't sound quite so much like sour grapes. However, I was reminded, when reading the judgment in Woodcock, somewhat of a trusts case as an undergraduate, which some of you may remember, called Regal Benkian No. 2. And you may recall that was a dispute about the trust of the immensely wealthy Mr. Kalus-Gulbenkian. There we are. I feel a picture of a man with a moustache enhances any lecture. And whether his trust was certain enough such that his son would get the money or another female member of his family would get the money. So you would sit through three immensely long lectures trying to reconcile two conflicting lines of authority. And some of the analysis being so complex it required mathematical equations to bring together those cases in what we were sure would be revealed to be some grand unifying principle of trusts. Having done that, what a disappointment it was to be told by your professor at the end, in what may be an apocryphal story, that the real reason for the latter judgment you'd worked so hard to reconcile was simply that the court were determined that that woman was not going to get money. Now, whilst the reasoning is not quite so stark here, what one inevitably takes away from this case in particular is that sometimes very particular factual circumstances and sometimes largely policy reasons can lead to a decision which is difficult to reconcile and apply more generally. Now, it's relevant, I fear, to know a bit about the facts of Woodcock to see how the courts arrived at the decision they did. Mr. Woodcock was formerly the chief executive of a NHS primary care trust. Prior to being dismissed, he had spent the entirety of his life working for the trust, joining as an undergraduate in the undergraduate scheme and working his way up at the age of 32 to being the youngest NHS chief executive at the time. Over the course of the quarter century of his career, he had accrued two particular rights. Firstly, to a 12-month notice period for dismissal, and secondly, an enhanced pension entitlement should he reach the age of 50 while still in the trust's employment. And it was a significantly enhanced pension entitlement. In 2006, several primary care trusts, including his, merged, and the chief executives had to apply for new roles. Mr. Woodcock wasn't initially successful, but was told by the head of the Strategic Health Authority that there was lots of work to be done in the meantime. Jobs would be likely to come up for chief executives in about a year's time. He should keep his head down and work on secondments, etc., which he duly did. And at all those times, it was expected that at some point his employing primary care trust would begin consultation with him as to potential redundancy, or it was thought more likely, his next possible role. It accordingly came as some surprise to Mr. Woodcock, before consultation began, to be sent a letter giving him 12 months' notice of dismissal. Now, the reason for that, as you may be aware, is that Mr. Woodcock was age 48 at the time and due to turn 49 on the 17th of June of that particular year. Had the redundancy consultation process started, that would have run its normal course, and he would very soon have reached the age of 49, after which, with his 12 months' notice, he couldn't have been dismissed for a year, and his entitlement to that substantially enhanced pension would have been triggered. And as a consequence, one could see from the correspondence that the penny dropped within the management, and there was a lot of rushing around, and the decision was made peremptorily to dismiss Mr. Woodcock by serving an early notice of dismissal before the consultation process had begun. At no point was he told that was the reason for serving the notice, and perhaps understandably, Mr. Woodcock devoted his duties to trying to get that notice withdrawn before the consultation took place. There are a number of factors that are worth bearing in mind. I'll pick out some key ones that are particularly telling, bearing in mind this is a case where the justification has to be a legitimate aim. Firstly, the person who made the decision to serve the early notice on Mr. Woodcock was the chief executive of the trust, and she had never met with or never spoken to Mr. Woodcock. She gave evidence that she was of the view that the consultation process was being carried out by the head of the Strategic Health Authority. The head of the Strategic Health Authority gave evidence that he was of the view that the consultation was being carried out by the Primary Care Trust, and as a result the consultation didn't take place. And at no point did anybody suggest to Mr. Woodcock that he should consider a lesser post than chief executive, and if he didn't do so, he was likely to be dismissed. And it was against that background that the tribunal came to determine, or came to have to determine, whether Mr. Woodcock's treatment was justified on the grounds of age. It was the Trust's primary defence, right up until the time of the tribunal, that age was not the reason in any way, and justification was a very briefly argued alternative. In any event, the tribunal heard the evidence of the trust witnesses and Mr. Woodcock over the course of a week and came to the conclusion that age was the reason. The significant factor was that he was due to hit 49. The tribunal then also went on to make a number of telling findings as to the reasons for that particular decision. The tribunal found that the chief executive's reason for the early notice was that she felt she had a duty to look after the financial side of the trust, which was the taxpayers' money. Also telling as to the reason was the way the respondents put the reason for serving notice. They stated that the dismissal was justified as a proportionate means of achieving a legitimate aim because the termination avoided incurring a vast and unnecessary additional cost. And lastly, the tribunal itself made a finding as to the reason. They stated it was the reasonable need of the respondent to bring about the end of Mr. Woodcock's employment without incurring cost to the taxpayer. Now, in the tightly prescribed laws of lectures that I apply to myself, every lecture should have a quiz, some statistics, and an amusing anecdote. And this is the point for the quiz. It'll be interesting to see, against those findings, what you feel is properly categorised the reason for the early service of notice on Mr. Woodcock. Was it properly analysed, A, to avoid the windfall of an unearned benefit? B, was it the achievement of the dismissal of an already redundant employee? Or was it C, cost? And before you answer, I'll give you a clue. The answer is C. It's very difficult. It's well nigh impossible, although the Court of Appeal did do it to their credit, to categorise the dismissal of Mr. Woodcock or the advancement of the date of his dismissal as anything other than cost. In any event, that's the background. The extant legal position would, on the face of it, appears to be relatively straightforward, that one cannot, as an employer, justify age discrimination on the grounds of cost. Notwithstanding that, all three courts that looked at it found Mr. Woodcock's early notice justified, and you'd be forgiven for asking how that could have come about. Now, what quite clearly appeared to be telling against Mr. Woodcock was the fact that at the time of his dismissal, he had already received quite a significant lump sum on termination of some £220,000, and the cost of the enhanced pension to the trust would have been a further £500,000. And one can't help but speculate that in the current financial climate, and perhaps somewhat reminiscent of the possibly apocryphal motive in Regal Benkian, that the tribunal had decided that whatever the strictures of European case law, that man was not going to get the money. There certainly, it has to be said, appears to be a growing judicial momentum towards the idea that cost alone can justify age discrimination, which I will turn to shortly. In any event, the ostensible way in which the tribunal and the latter courts justified or found Mr. Woodcock's age discrimination to be justified was on the basis of a doctrine of windfall. And if that's going to be utilised, it's important to understand when it is windfall is going to be a permissible reason for dismissal or for age discrimination, and when it is it will be deployed, and what are the parameters of that. In finding that windfall was the reason for the discrimination against Mr. Woodcock as opposed to just cost, the courts relied upon a rationale that originated in Locksley and BAE Systems in 2008. Now, in that case, Mr. Locksley claimed age discrimination on the basis of his exclusion from the benefits of a redundancy scheme by reason of his age. Now, the redundancy scheme in that case had been in existence for some years and had been agreed after lengthy talks between the employers and the unions. And that scheme provided that employees got redundancy payments based upon their years of service. And that increased up to a point, but after a point there was a tapering provision as you got closer to retirement. And the reason for that, discussed and agreed with the union, was that the redundancy scheme was supposed to cushion the effect of redundancy. As you got closer to retirement, you got closer to your pensionable age. And as such, if you got both the redundancy scheme payments and your pension in the last 3 years of your employment, you would end up with more money than you would ever have got if you had simply worked up until retirement age. So the windfall in that case can truly be said to be something that was unearned, unintended, and in the course of the inception of the scheme had not been intended to take place. And one has to ask if that sort of windfall is in any way analogous to what had happened to Mr. Woodcock. In order to deprive Mr. Woodcock of the benefit of his enhanced pension, his employers had to adopt, without any discussion with him, a clandestine age-based rationale, and in doing so dispensed with consultation, which we always hear is so important in relation to redundancy exercise, of an employee who'd worked for them for 25 years, had spent his whole life accruing skills to be used for the NHS. So, looking properly at the parameters of windfall, arguably what they should be is the following. That they can be said to be a windfall justifying age discrimination where there is an unearned benefit that was unintended that will accrue to the employee by reason of the age-based provision, in circumstances where the curtailed benefit was never intended, and also where the avoidance of that unearned benefit is proportionate and amounts to a legitimate aim. And one has to ask whether windfall, as set out in Locksley, is anyway, in reality, applicable to Woodcock, or whether that is an instance of the court doing the find another factor exercise talked about by Mr. Justice Underhill, ironically in the judgment in Woodcock, and an element of artificially arising in that case. To understand how two appellate courts could come to the conclusion that Mr. Woodcock's clandestine treatment was justified, it's worth looking at the history of justification generally. The justification for discrimination arose originally in European cases in relation to indirect discrimination. And you'll all be familiar with the test of a proportionate means of achieving a legitimate aim. And that test for justification was in due course incorporated into domestic law, into the Equality Act, and the previous iterations of age discrimination protection. Now, in terms of cost as a justification, some of the early cases suggested that cost might be a permissible. Excuse me, that was not a Pinterest dramatic pause. The cost might be a permissible justification, might be a permissible rationale for justification. Some of the matters that were held to be potential justification were efficiency, avoiding absenteeism, and in certain cases, in Allenby for instance, it was suggested that the saving of the money could be a legitimate aim. However, there were two more recent lines of authority that dealt specifically with cost as a justification, the Rocks line of authority and the Hill line of authority, that were brought together by Mr. Justice Burton in relation to employment cases. The Rocks line of authority applied in relation to states and said that states can't rely on budgetary consideration. The Hill line of authority dealt with employers and found that employers couldn't rely solely upon cost as a justification. And bringing those cases together in a very closely reasoned judgment, Mr. Justice Burton arrived at the decision in Cross and British Airways, and what we now have, the cost plus rationale, the current position that an employer can't rely upon cost alone, there has to be some other factor. However, when looking at the decisions of the EAT and the Court of Appeal in Woodcock, it's worth bearing in mind that there appears to be a rising tide in favour of the idea that, notwithstanding the European jurisprudence, cost alone should be able to justify discrimination, or is capable of being a legitimate aim. Certainly in the context of equal pay, cost has been something that is held to be permissible reason for differential treatment of men and women. But most explicitly, in Woodcock, Mr. Justice Underhill made it clear that he felt constrained by the European jurisprudence, but he felt that he found it hard to find why it was that cost alone could not amount to a legitimate aim in itself. And one sees that informing his decision very much. And that obiter comment can be seen to now have effect on other areas of discrimination other than just age itself. In the case of Churphy and G4S Security in 2010, in an indirect religious discrimination case, it was found to be justifiable not to allow an employee to have Fridays off to go to the mosque on the basis of the saving of costs. So that rising tide is beginning to manifest itself in a number of ways. And where does that leave us in relation to the situation of whether whether an employer can discriminate on the grounds of age and justify that on the grounds of cost? Well, the ostensible position is that they cannot do so simply on that basis. But the underlying factors that everybody will be aware of is the growing judicial momentum in relation to the idea that cost alone may justify or may be a legitimate aim, and that is manifesting itself in a very wide approach to what is being taken to a cost plus rationale, with the bar being laid very low. So it remains to be seen whether Woodcock is the high watermark for costs as a justification, or whether it's a temporary bulwark that will be swept away in due course. So we're left with an unfortunately uncertain situation, not an attractive position either for employers or employees, but that unfortunately is where we are. Now, I said I would deal briefly with Selden and Homer. I've set out my comments, in fact, in those very fully in my handouts at page 18 to 19. So for strictures of time, I won't go through those at this point. I'll deal very briefly with two recent European cases and one employment tribunal case. Those two European cases are Torsten Hornfeld, and that was a Swedish case in relation to the compulsory retirement age, or the compulsory potential retirement age in Sweden of 67, where the CJEU found that that was something that was permissible. It was permissible because the age was 67 rather than 65, and it's noticeable that where it was thought the door was shut on compulsory retirement ages, it looks like it is not entirely shut and they may resurrect themselves. Tyrolean Airways is a case about what constitutes and what doesn't constitute age discrimination, and one factor of age discrimination cases often is that age is not a binary factor. It's not just black or white, you are a particular race or not. It's a moving continuum, as Dinah Rose said so eloquently in a case, and I'm plagiarising at this point, that changes over the course of a career. And for those reasons you often ask yourself, is this age discrimination or not? And in Tyrolean Airways, it was found that failing to take into account the history of employment with previous companies within a group was not age discrimination. It was simply a manifestation of when or who particularly you choose to work with. And Dumbreck and Ofcom, lastly, is an employment tribunal decision, but one that is worth reading, particularly the minority judgment about whether a move from a defined benefit scheme to a defined contribution scheme is permissible or is age discrimination. And the tribunal as a whole found it was not, but the minority member found that the older you were, the less time you had to rectify the things that were difficult in a badly administered defined contribution scheme. So I can see I'm coming up to my time. As a result, you've had some statistics, you've had the quiz, you won't get the amusing anecdote, you'll just have to guess what these slides would have meant. And if anybody wants to approach me afterwards, I'll tell you.